Hello everyone, and welcome back to the channel. I am Mr. Kelly, your immigration analyst. Today I have a breaking immigration update that every single person in the United States immigration system needs to hear right now. Whether you are a green card holder, an H-1B worker, an F-1 student, a K-1 fiancé visa applicant, someone waiting for a family-based petition, or an asylum seeker, the rules of the game have changed in multiple ways over the past few days. Some of these changes took effect just 1 week ago, and many people still do not know about them. In this video, I am going to walk you through every new rule that has been announced, explain exactly how each one affects different categories of immigrants, break down the numbers and the deadlines, and give you clear action steps so you know exactly what to do to protect your immigration status. Let us get straight into it. The first major rule change. Starting March 30th, 2026, the United States Department of State expanded its mandatory social media screening program to 14 additional non-immigrant visa categories. This is a massive expansion that affects hundreds of thousands of applicants. Previously, social media vetting was required mainly for H-1B, H-4, and certain immigrant visa applicants. But now, effective March 30th, 2026, the following categories have been added to the mandatory social media screening list. K-1 fiancé visas, K-2 dependent children of fiancés, K-3 spouse visas, R-1 religious worker visas, R-2 dependents of religious workers, H-3 training visas, A-3 employees of diplomats, C-3 domestic workers of foreign government officials, G-5 employees of international organization representatives, Q cultural exchange visas, S informant visas, T trafficking victim visas, and U crime victim visas. What does this mean in practical terms? It means that if you are applying for any of these visa categories, the consular officer reviewing your application will now check your social media accounts as part of the standard vetting process. This is not optional or random. It applies to every single applicant in these categories. The State Department has also instructed applicants to make their social media profiles public so that officers can review them. If your profile is private, the officer may ask you to provide access, or they may use the fact that your profile is private as a reason to request additional information or delay your case. This is critically important for K-1 fiancé visa applicants, because K-1 is one of the most popular visa categories for couples planning to get married in the United States. Consular officers will now review your social media to verify that your relationship is genuine. They will look at your posts, your photographs together, your check-ins, your comments, and your communication patterns. If your social media does not show evidence of a real, ongoing relationship, it could raise red flags and lead to additional questions or even denial. The same applies to religious workers on R-1 visas. Officers may review your social media to verify your religious activities and your affiliation with the sponsoring organization. For T and U visa applicants, who are victims of trafficking and crime, officers will now screen their social media as well, which could add time to already lengthy processing periods. My advice is simple. If you have any visa interview coming up in any of these categories, review every single social media account you have right now. Remove anything that contradicts your application. Make sure your profiles are consistent with what you have told USCIS or the consulate, and be prepared for the officer to ask about specific posts or photographs they have found during their review. The second major rule change. Starting April 1st, 2026, USCIS stopped accepting the old edition of Form I-129. This is the petition form used for non-immigrant workers including H-1B, L-1, E-3, O-1, P-1, R-1, and other work visa categories. Only the new edition dated February 27, 2026 will be accepted. If your employer or attorney submitted a petition using the old January 20, 2025 edition of Form I-129 on or after April 1, 2026, that petition will be automatically rejected. Not denied. Rejected. That means it gets sent back without any processing, and you will lose the filing fee, lose time, and have to refile with the correct form. This is especially important right now because the FY 2027 H-1B cap filing window just opened on April 1, 2026. USCIS completed the H-1B lottery selection process by March 31, 2026, and selected registrants were notified. If you were selected, you now have until June 30, 2026 to file your H-1B petition, but that petition must be filed on the new I-129 form. If your attorney files using the old form, your case will be rejected and you could lose your lottery slot. Let me also share what is new about the H-1B system itself. The FY 2027 registration window ran from March 4 to March 19, 2026. For the first time, USCIS used a wage-based weighted lottery system. Under this new system, employers who offered higher wages received more lottery entries. Specifically, Level 4 wage offers received 4 entries, Level 3 received 3 entries, Level 2 received 2 entries, and Level 1 received just 1 entry. This means that higher-paid positions had a significantly better chance of being selected in the lottery. Combined with the $100,000 supplemental fee for new first-time H-1B petitions that has been in effect since September 21, 2025, the H-1B program is now fundamentally different from what it was even a year ago. Many smaller companies and startups are finding it extremely difficult to sponsor H-1B workers under these new conditions. If you were selected in the FY 2027 lottery, congratulations. But make sure your petition is filed before the June 30, 2026 deadline using the correct I-129 form edition, and be prepared for the $100,000 fee if this is a new first-time petition for a beneficiary outside the United States. The third major development. USCIS has made significant changes to Form I-485, which is the application to adjust status to permanent residence. There are 4 key changes you need to know about. First, your medical exam, Form I-693, must now be submitted at the time of your initial I-485 filing. Previously, many applicants would file the I-485 first and submit the medical exam later, either before the interview or in response to a request for evidence. That is no longer acceptable. If you file your I-485 without including the sealed I-693, your application may be rejected outright. This is a significant change because the medical exam has a limited validity period, and it requires scheduling an appointment with a USCIS designated civil surgeon, completing a physical exam, getting blood work done, and having all required vaccinations verified. This process can take several weeks, so you need to plan ahead. Second, the COVID-19 vaccination is no longer required for the immigration medical exam. As of January 22, 2025, USCIS waived the requirement for adjustment of status applicants to show proof of COVID-19 vaccination on their I-693. So your civil surgeon will not include it, and you will not be penalized for not having it. Third, USCIS now requires separate fee payments for each form filed concurrently. If you are filing I-485 along with I-765 for work authorization and I-131 for advance parole, each form must have its own separate payment. The I-485 filing fee is currently $1,440, which includes the biometric fee. And fourth, your Form I-130, which is the underlying family petition, must be approved or at least properly pending before you file I-485. USCIS is enforcing this requirement more strictly than before. These changes are critically important for anyone preparing to file a green card application this month, especially given the favorable visa bulletin dates that I will explain shortly. The fourth major rule. On March 30, 2026, USCIS released a major update on its strengthened screening and vetting procedures. This update directly affects hundreds of thousands of pending immigration cases. Since early 2025, USCIS has been placing holds on immigration applications from nationals of certain countries while conducting enhanced background checks. Many applicants from these countries have seen their cases frozen for months with no updates and no explanation. On March 30th, USCIS announced that it has now established an internal process for lifting holds on individual or group cases. This process requires comprehensive review by multiple USCIS offices before a hold can be removed. USCIS also confirmed that it has begun lifting holds for asylum seekers from non-high-risk countries who have cleared enhanced vetting. However, this does not mean all holds have been lifted. Cases involving nationals from countries that USCIS considers high risk may remain on hold for an extended period. And the process for lifting holds is multi-layered, meaning it will take time even for cases that qualify for release. If your case has been stuck with no update for months, this announcement may explain why. And if you are from a country that has been subject to enhanced vetting, check with your attorney to see whether the March 30 update affects your case. The fifth major development is the proposed rule on asylum work authorization. On February 23, 2026, the Department of Homeland Security published a proposed rule that would dramatically change how asylum seekers obtain work permits. Currently, asylum seekers can apply for an Employment Authorization Document, an EAD, 150 days after filing their asylum application. Under the proposed rule, that waiting period would increase from 150 days to a full 365 days. That means asylum seekers would have to wait an entire year before they can even apply for a work permit. But that is not all. The proposed rule also introduces a pause mechanism. If the USCIS processing backlog for affirmative asylum cases exceeds certain thresholds, USCIS could temporarily stop accepting new EAD applications from asylum seekers altogether until the backlog decreases. The rule would also require biometric collection, including fingerprints and photographs, for all initial and renewal asylum-based EAD applications. And remember, the maximum validity period for asylum-based EADs was already reduced in December 2025, from 5 years down to just 18 months. The public comment period for this proposed rule runs until April 24, 2026. If you are an asylum seeker or work with asylum seekers, I strongly encourage you to submit comments through the Federal Register website before that deadline. Organizations like the ACLU, the National Immigration Law Center, and ASAP together have published guides on how to submit effective public comments. The sixth major development is the layered travel ban system that is now affecting nationals of dozens of countries. Let me break down the full picture because it is more complex than most people realize. In June 2025, President Trump issued a proclamation restricting entry from 19 countries, effective June 9, 2025. Then, on December 16, 2025, a second proclamation expanded those restrictions to nationals of 39 countries, plus Palestinian Authority travel document holders, effective January 1, 2026. Some countries face full entry bans, while others face partial restrictions. On top of that, on January 14, 2026, the State Department announced a separate action pausing immigrant visa processing for nationals of 75 countries, effective January 21, 2026. This 75-country freeze affects family-based petitions, employment-based visas, and diversity visas. The only exception is for adoption cases. So as of April 2026, the United States has 39 countries under the expanded travel ban and 75 countries under the immigrant visa processing freeze. Some countries appear on both lists. Together, these restrictions affect tens of millions of people worldwide. Multiple lawsuits have been filed. The ACLU, the National Immigration Law Center, and a group of U.S. citizens sued the State Department on February 2, 2026, arguing that the 75-country ban is an illegal nationality-based blanket denial. Additional legal challenges are targeting the 39-country travel ban. As of today, both restrictions remain in full effect while the cases are litigated. Now the seventh development, and this is the good news. The April 2026 Visa Bulletin brought some of the most positive movement in years. For the first time in a very long time, EB2 employment-based second preference is now current for all countries except India and China. EB3 employment-based third preference is now current for rest of world and Mexico. For India, EB2 has advanced 10 months to July 15, 2014. This is significant forward movement that many Indian nationals have been waiting years to see. EB3 India has also moved forward. EB2 China remains at September 1, 2021, with no movement this month. For family-based applicants, the F2A category, covering spouses and minor children of green card holders, is now current for filing purposes. This opens the door for thousands of families to begin the adjustment of status process. USCIS has confirmed that the dates for filing chart will be used for all employment-based categories in April 2026. This chart is more favorable than the final action dates chart, giving applicants 6 to 14 months of additional filing eligibility. If your priority date is current, this is your window. File your I-485 immediately. But remember the new rule. Your medical exam I-693 must be included with your initial filing. Do not file without it, and make sure you submit separate payments for each concurrent form. These visa bulletin dates can retrogress in future months, meaning they can move backward. If that happens, you lose your eligibility to file until the dates advance again. So do not delay. Act now. Now here are your 7 action steps for April 2026. Number 1. Check the April 2026 Visa Bulletin on the State Department website today. If your priority date is current, start preparing your I-485 package immediately. Complete your medical exam with a USCIS designated civil surgeon and have the sealed I-693 ready to include with your filing. Number 2. If you have any pending or upcoming Form I-129 petition, verify right now that your attorney is using the new February 27, 2026 edition. Any petition filed on the old form after April 1, 2026 will be automatically rejected without processing. Number 3. If you were selected in the FY 2027 H-1B lottery, file your petition before the June 30, 2026 deadline. Use the correct I-129 form. Be prepared for the $100,000 fee if this is a new first-time petition. And consider premium processing if timing is critical, but note that the premium processing fee increased to $2,965 on March 1, 2026. Number 4. If you are a K-1 fiancé visa applicant or fall under any of the 14 newly added social media screening categories, review all of your social media accounts immediately. Remove anything that contradicts your application. Make your profiles consistent with what you have told the consulate. Be prepared for the officer to ask about specific posts. Number 5. If you are an asylum seeker, be aware of the proposed rule that would increase the EAD waiting period from 150 days to 365 days. Submit public comments through the Federal Register before April 24, 2026, and consult with an immigration attorney about how to protect your ability to work. Number 6. Track every immigration document expiration date you have. Green card renewals on Form I-90 are now taking over 8 months. EAD renewals are also taking longer due to the reduced 18-month validity period. Set reminders in your calendar 6 months before any document expires and file renewals early. Number 7. Consult an experienced immigration attorney. With this many rule changes happening simultaneously, professional guidance has never been more critical. Whether you are filing a new application, responding to a request for evidence, affected by the travel ban or the 75-country visa freeze, or unsure about what to do next, a qualified immigration lawyer can help you avoid costly mistakes. Before we wrap up, here are 7 numbers you need to remember from today's video. Number 1. March 30, 2026. That is the date social media screening expanded to 14 new visa categories, and the date USCIS announced it is beginning to lift case holds for non-high-risk country nationals. Number 2. April 1, 2026. That is the date after which the old Form I-129 will be rejected, and the H-1B filing window opened for FY 2027 selected registrants. Number 3. April 24, 2026. That is the deadline for public comments on the proposed asylum EAD rule that would increase the waiting period to 1 year. Number 4. June 30th, 2026. That is the deadline for filing FY 2027 H-1B petitions if you were selected in the lottery. Number 5. 75 countries under the immigrant visa processing freeze. 39 countries under the expanded travel ban. Number 6. $100,000. That is the supplemental fee for new first-time H-1B petitions. Number 7. EB2 and EB3 rest of world are current in the April 2026 visa bulletin. If you are eligible, file your green card application now before the dates retrogress. The American immigration system is changing faster right now than at any point in recent memory. New rules are being introduced every single week. Social media screening is expanding. Filing requirements are changing. Travel bans are layered on top of visa freezes. Processing times are getting longer. And fees are going up. The only way to protect yourself, your family, and your immigration status is to stay informed, stay organized, and act quickly when opportunities arise. Knowledge is your most powerful tool in this environment. I will continue covering every single immigration development on this channel so that you always have the most current and accurate information available. I do this every week so you never have to guess about what is happening. If this video was helpful, hit the like button right now. Share it with someone who needs this information. There are millions of people who do not know about these changes yet, and sharing this video could make a real difference in someone's life. Subscribe to the channel if you have not already, and tap the bell icon so you get notified every time we post a new video. Drop a comment below and tell me which of these rule changes affects you the most. Are you a K-1 applicant worried about the new social media screening? An H-1B worker dealing with the $100,000 fee? An EB2 or EB3 applicant who just discovered your priority date is current? An asylum seeker concerned about losing your work authorization? Tell me your situation. I read every single comment, and I will do my best to answer your questions personally. I am Mr. Kelly, your immigration analyst. Thank you for watching, and I will see you in the next video. Take care.